Good afternoon, all. In this video, I will be covering H1B visas. I will not be including any opinions on them, as this video will be strictly informational. First, I will discuss what the visas are, establishing who they are for and how they are defined legally. Then, I will go over the regulations surrounding the visas, such as numerical limits, the cap, what counts towards it, the employer's responsibilities, procedures, etc. Once we've covered the underlying laws and regulations, we can lay out a plain English definition of who can get H1B visas and how they're obtained. After I cover the underlying information, we will go over statistics surrounding the visas and their usage. In this section, I'm aiming to provide a comprehensive view of who the visas are being issued to and how different sectors and demographics are represented among visa holders. I hope you're able to get something useful out of this video, and as always, if you feel I've made a mistake or misrepresented something, please let me know in the comments and provide a source for your correction. Thank you. So, what is H1B? High level, it's a type of visa that allows a person from another country to work in the US for a specific employer for a limited term. Also important to note for general understanding is that employers are the ones who petition for H1B visas, not the prospective employees. These petitions are filed for each prospective employee that the firm wishes to hire and are subject to a lottery selection system that we will delve deeper into later. But again, you're not here for high level, so let's start by taking a look at the text of Title 8 US Code 1101 H1B. I'll save us the trouble of reading the entire text and keep it to the most relevant parts. If you want to read the entire text, it will be linked below. Quick forward here. There are a few references to parts of the US Code in the following text, but rest assured that they will be covered as well. So, without further ado, an H-1B worker is, and this is from the US Code, an alien subject to Section 1182I2. This section is the one which limits the ability of foreign medical school graduates who are coming to work in the medical profession to be admitted to the U.S. under H-1B to those who are either invited by an educational or research institution or agency in the U.S. to teach or conduct research for that institution or agency, or have passed the federal licensing examination or an equivalent exam recognized by the Secretary of Health and Human Services and has competency in oral and written English, or is a graduate from a medical school accredited for that purpose by the Secretary of Education. Back to the U.S. Code. So where we left off is an alien subject to Section 1182I2 of this title who is coming temporarily into the U.S. to perform services in a specialty occupation described in Section 1184I1 of this title. So Section 1184I1 defines a specialty occupation as an occupation that requires theoretical and practical application of a body of highly specialized knowledge and attainment of a bachelor's or higher degree in the specific specialty or its equivalent as a minimum for entry into the occupation in the US. So, plain English, what this means is that these visas are for workers who are going to be working in fields where in the US there is a specific degree requirement as a typical barrier to entry or a level of experience which would be roughly equivalent to that of a degree. Moving on. The section clarifies further that the requirements for a specialty occupation are full state licensure to practice the given occupation, if the given occupation requires it, completion of the requisite degree mentioned in the definition, or experience in the occupation equivalent to the completion of a degree and recognition of such expertise shown by holding positions of increasing responsibility in that specialty. There's also a provision for fashion models, but I will skip this as the number of visas awarded for fashion models doesn't even show up in the data. In addition to H-1B visas, the section also discusses H-1B1 visas, which are largely similar but have a few key differences which we will discuss later. So, to summarize before we move on to the mountain of rules around H-1B visas, H-1B allows temporary entry into the U.S. for foreign workers who hold at least a bachelor's degree or other equivalent qualifications in a specialized field to work for a specific company that has sponsored their visa. So, on to the rules, of which there are a lot. So, let's start with the overall governance, and then we can go over the procedure. So, most of the rules discussed here can be found in Title 8 US Code 1184, so for those following along at home, I'll mention the specific section I'm discussing at a given time. Quick background, the United States Citizenship and Immigration Services, herein referred to as USCIS, is the main governing body of H-1B visas and related activities. There is a cap on the amount of new H1B visas that can be issued in a given year at 65,000. This cap has numerous exemptions, which is why the total amount of H1B visas issued in a year typically is drastically higher. For example, in 2023, there were 386,313 approved H1B petitions according to USCIS. So, exceptions to counting and other rules. So, this is from Section G, the same title. On top of the 65,000, there are an additional 20,000 visas that can be issued to foreign workers who hold an advanced degree, which is master's or higher, from a U.S. institution. So this is also in addition to the spouses and children of H-1B workers are not counted towards the limit. If a visa holder who has been counted towards the cap in the year in which the visa was issued is found to have obtained the visa through fraudulent means, such as misrepresentation of material facts, or if their non-immigrant status is otherwise revoked, one visa will be added to the cap in the year in which the visa was revoked, not the year the visa was issued. So, let's say an H-1B worker who is counted towards the cap, increasing the hypothetical amount of visas counted towards the cap from 100 to 101, is found to have obtained the visa through fraudulent means. Their contribution will be removed from the cap in the year in which their status was revoked. So if the status were to be revoked in the same year in which the visa was issued, the counted visas would go back to 100. Or if it was a year later, the counted visas on that year would be reduced by 1. So if 100 visas are counted in the next year, the revocation would drop that number down to 99. So here's where one of the differences with H1B1 visas comes in. The total cap of H1B1 visas is set aside from the 65,000. So this means of that 65,000, there are 1,400 slots reserved for Chilean nationals and 5,400 slots reserved for Singaporean nationals. So of the 65,000, there are 6,800 slots reserved specifically for H1B1 visas. Moving on. H-1B visas issued for employment at the following areas are also not counted towards the cap: institutions of higher education or affiliated nonprofit entities, nonprofit or governmental research organizations. If an H-1B worker who has previously been exempt from the cap due to working in one of the aforementioned areas switches into a non-exempt field, they will be counted towards the cap the first time they are employed by a non-exempt employer. So, if an H-1B worker works for a university, but is then hired via another H-1B petition from, let's say, Walmart, whom, to my knowledge, does not constitute an institution of higher learning or a research organization, they will then be counted towards the cap at the date which they began employment at Walmart. So, in addition to this, H-1B visas are limited to 6 years, with some exemptions which we will cover later. Due to this, an H-1B worker is only counted towards the cap in the year which they receive their initial visa. So, year 1 is counted towards the cap. And assuming that this worker stays for the full 6 years, years 2 through 6 are not counted towards the cap, unless they were initially non-exempt and then moved into initially exempt and then moved into a non-exempt field, as we discussed before. So, there is a 1-year interim period at the end of these 6 years that the worker must wait before they are able to receive another H-1B visa. And if they do get this new visa after this 1-year waiting period, they will be counted towards the cap again at the beginning of the new 6-year period. Okay, so that's how H-1Bs are counted towards the cap, and why the actual number of approved H-1B petitions is far above that 65,000 cap. And when we go into the data a little bit later, you'll be able to see this more visually, and I think it'll make a little more sense. So before I go into the process that employers use to hire H-1B workers, I want to quickly mention some exceptions to that 6-year rule. So if an I-140 immigrant petition, which is the petition to receive a green card, or an alien labor certification, which is a preliminary step in the green card process, has been filed on the visa holder's behalf before the 6th year their H-1B status begins, and they have not received this decision on this petition, they can extend their H-1B status in 1-year increments until they receive a decision. If a visa holder has an approved I-140, but they do not have a current priority date, which is the date that they declared their intention to immigrate and thus cannot finalize the green card process, they can extend their H-1B status by 3 years until the green card process is able to conclude. An H-1B visa can last up to 10 years if the visa holder is working on some Department of Defense research projects. So essentially, extensions beyond the 6 years only really apply when there are delays in the processing of certain immigration forms or if Uncle Sam wants you working on some special project. Protections also exist for H-1B workers. In the event that their employment terminates, rendering their H-1B status invalid, H-1B workers are given a 60-day grace period after their termination of their job, either voluntarily or involuntarily. During this time, the H-1B worker is able to seek and accept employment at another firm that is able to employ H-1B workers, change their immigrant status, such as switching to the dependent of an H-1B worker, a student, a visitor, etc. If the worker does not elect to seek reestablishment of their non-immigrant status or is otherwise unable, the employer must pay for the transportation and other costs that reasonably allow the non-immigrant to return to their residence they departed from at the start of the H-1B job. So now moving on to the procedure. So, the procedure. The process of a foreign worker obtaining an H-1B visa can be broken down into a few steps. Initially, the employer looking to hire an H-1B worker must file a petition, which is now done electronically, with USCIS and pay the mandatory fee of $215 per petition. This used to be $10 per petition until fiscal year 2025. So, once these petitions are filed, they are entered into the H-1B lottery. The lottery has gone through a number of iterations in how it selects the petitions that can continue the process for an H-1B visa, and currently, the lottery aims to provide an equal chance to every applicant for that 65,000 base cap. To achieve this, they require petitioners to submit the prospective visa recipient's passport or other identification that they will be using to enter the U.S., or receive the visa. This is presuming the visa is approved. And select out of the pool of individuals who have received at least one petition rather than selecting random petitions. This is done because multiple petitions can be filed on an H-1B worker's behalf, so from different employers. So what about petitioners who would qualify for the advanced degree exemption? Remember that extra 20,000 cap for those with master's or higher. The initial lottery for all H-1B petitions is from the same pool, meaning that if you qualify for the 20,000 additional slots for advanced degree holders, there's no special treatment in this round. If there are a sufficient number of advanced degree holders to meet that 20,000 cap from the first lottery, no additional lottery will be run specifically for advanced degree holders. But if the advanced cap is not met, the lottery will be run specifically for those degree holders. If there are enough advanced degree holders who qualify for the regular cap to drop the amount of non-exempt petitions below that 65,000 number, the lottery will then be run for the entire applicant pool again, regardless of degree. So let's say, you get enough to fill that cap for the exempt workers, but then when you take them out to fill that cap, there's actually under 65,000. They'll run another lottery to get up to that 65,000 number. Then the select petitions are able to move on to the next step, which is the labor condition application, which an employer must file with USCIS. This application is an attestation by the employer that they are not in violation of any of the following requirements. First, H-1B workers must be paid the higher of the prevailing wage or the employer's actual wage for employees of a similar level and experience. The prevailing wage can be determined by obtaining a wage from the National Prevailing Wage Center or by a reputable and legitimate source for wages, which must be cited on the form the employer submits to verify the prevailing wage. The advantage for just using the prevailing wage from the National Prevailing Wage Center is that there is a safe harbor condition during wage compliance investigations pertaining to the prevailing wage used by the employer. This wage requirement also applies to benefits such as bonuses or insurance coverage. The working conditions that an H-1B worker will be subject to are in line with the working conditions of U.S. employees of similar status. The employment of the H-1B worker must also not adversely affect the existing working conditions of U.S. employees, including shifts, hours, and the like. If there is an ongoing strike or lockout pertaining to a labor dispute for the occupation/area that the H-1B worker will be hired for, the LCA will not be approved. And finally, they have notified the head of their employee bargaining representatives, like a union head, or if there is not one, they have posted the notice in the locations where employees would likely see it that they are going to hire an H-1B worker and that this LCA has been filed. So, some other requirements. In addition to the LCA, labor conditioning application, an employer cannot fire or otherwise displace a U.S. worker holding an essentially equivalent job within 90 days before or after the filing of the LCA. This includes firing the employee, then offering them a job that the employer does not expect that employee to take, entering a temporary contract with the employee that would terminate when the H-1B worker would start, such that the employee is essentially fired, but slower. And an employer cannot pressure an employee to quit to make room for an H-1B worker. The employer can, however, offer an employee in good faith that grant an employee an offer in good faith that exceeds their base compensation and responsibility, or is equal to. In addition to this, there's a clause for secondary displacement, and this means that the employer cannot place the H-1B worker with an additional employer if there exists a relationship between that H-1B worker and the secondary employer. So basically, like, this means that a company can't hire an H-1B worker under their name and having, followed all the rules, but then have them perform employment-like duties for another employer unless that other employer can prove that they have not laid off a U.S. worker 90 days before or after the H-1B worker is placed with that other employer. So you can't have your buddy hire an H-1B worker and then fire one of your guys to basically have them shift over. In addition to not displacing U.S. workers, an employer must show good faith efforts to hire qualified U.S. workers for the position that the H-1B worker would be filling. So this good faith effort is generally the industry standard as determined by consulting groups or the like that is approved by USCIS. This clause also states that the employer cannot discriminate against U.S. workers and must offer equal or higher compensation to that of the potential H-1B worker and adhere to the aforementioned industry standards for recruitment. So moving on, after the LCA is approved, we get to Form I-129. So again, once the LCA is approved, the employer files Form I-129, which is the petition for a non-immigrant worker, which contains the certified LCA, the employee's information and qualifications, and a description of the job with the salary and benefits and the like. Once this form is approved, then and only then is H-1B status approved, and the employee is able to start work at the specified date. If they are in the U.S. already under another permitted status, like a student visa, they just need to wait for the start date, and then they can start working. But if they are outside the U.S., they use Form I-129 and their documentation to obtain the visa and then enter the U.S. So, as we mentioned before, there is another similar visa called H-1B1, and now we're going to go over some of those differences. So, H-1B visas are open to all, but H-1B1 visas are limited to those from either Singapore or Chile. H-1B visas have a 3-year duration with the option of extending to 6 years maximum, while H-1B1 visas have a 1-year duration but can be extended indefinitely, but only in 1-year increments. And every 3 years, the employer must file a new labor condition application to continue extending the visa. For H-1B1, the specialty occupation requirement extends to both agricultural managers and physical therapists for Chileans and management consultants and disaster relief claims adjusters for both Chileans and Singaporeans. H1B visa holders can have the intent to immigrate to the US, while H1B1 visa holders cannot. So this means if you're an H1B1 visa holder, you can't show that you want to gain full citizenship in the US or get a green card. Otherwise, your H1B1 status will be revoked. Whereas H1B, you can file petitions to become an immigrant, get a green card and all that. Now, on to everyone's favorite topic of discussion, fees. So, given H1B visas and their political scrutiny, there are a load of rules around the fees paid for the various forms in the H1B process and what they could be allocated towards. So, as we mentioned earlier, there's that $215 per beneficiary registration fee as of fiscal year 2025. So, for the filing of an H1B petition for a non-small employer, the base fee is $730 for an online filing, additional fee of $600 for all regular, which is non-exemption, filings for an asylum program fee. This fee is reduced to $300, generously, if the employer has 25 or fewer employees. There's a $500 fraud prevention and detection fee, and there is a $4,000 fee if they fall into the previously mentioned fee, employ 50 or greater employees, and if 50% or more of those employees are H1B, L1A, or L1B non-immigrants. There is also an American Competitiveness and Workforce Improvement Act fee of either $1,500 for employers with more than 25 employees and $750 for employers that have 25 or less employees. This fee is intended to fund the training of U.S. workers. To try and balance out the labor force, I guess. So at the discretion of the employer petitioning for the H-1B worker, they can file for premium processing and pay a fee to have the forms expedited. This fee cannot be paid by the beneficiary. So for Form I-129, for an H-1B worker, this fee would be $2,805. All right, so that's all the legal information regarding H-1Bs, so let's build out a consolidated answer to the question, what is H-1B? That incorporates the key elements of the regulations and rules that we have previously discussed. So, the definition that I have consolidated is as follows. H-1B is a program that allows employers to hire foreign workers of specialized skill on a temporary basis, mostly limited to 6 years. These workers are considered non-immigrants but can intend to immigrate to the U.S. at a later date. H-1B visas are meant to supplement workforces where there is not a large enough supply of U.S. workers for the given job. Protections exist to enforce this intention, such as the requirement that employers seeking H-1B workers must first make a good faith effort to hire U.S. workers, and cannot otherwise fire or displace an existing U.S. worker in the role around the time that the employer is attempting to hire the H-1B workers. The issuance of H-1B visas are subject to a cap of 65,000 visas per year, but there are notable exceptions to this cap. H-1B workers who are extending their stay, which they're able to do up until that 6-year limit, are not counted towards the cap. H-1B workers who hold an advanced degree, which is master's or higher, have an additional cap of 20,000. H-1B workers who are entering research fields, either for government or nonprofit entities, are not subject to this cap. Also exempt from this cap are those entering roles at higher education institutions or related entities. The process of obtaining an H-1B visa is initiated by the employer, not the employee. The employer files a petition to enter the lottery for H-1B visas, which is how the USCIS manages an adherence to the aforementioned cap. If selected, the employer must then submit a labor condition application to attest to the working conditions, pay, and benefits that the H-1B worker will be receiving are on par with that of its other employees and that of U.S. industry standards. This attestation cannot be filed if there is an ongoing labor dispute at the firm. Protections also exist that in the event that an H-1B worker is fired from the job that affords them their H-1B status, or if they quit. There is a 60-day grace period after the last payment is received from the job, in which they can seek different H1B employers or change their visa to a different non-immigrant status. If they are unable or unwilling to do so, the employer must cover their costs for returning to their prior residence before the start of their H1B tenure. All right, as promised, we're going to look at some of the data around H1B visas and their issuance and their demographics and all that. So, without further ado, now that we have a decent understanding of the underlying laws and regulations around H1B, let's look at the 2023 report to Congress by USCIS titled Characteristics of H1B Specialty Occupation Workers. During fiscal year 23, there were 386,559 petitions filed for H1B workers, which is a decrease from 474,301 in fiscal year 2022. The report attests that the drop in petitions can be attributed to a decrease in the number of H1B holders looking to switch employers, which decreased from 123,888 in fiscal year 2022 to 75,843 in 2023. Additionally, fiscal year 2021 had 3 rounds of the lottery, which pushed some of the approvals into fiscal year 2022, inflating the number of approved petitions. The breakdown of petitions that were for continuations for employment versus new H1B issuances were 70% and 30% respectively. This is largely in line with previous years, which is shown on screen. The approvals can be broken down further, as the 70% continuations of visas fall into the following categories. 23% are extensions of stay, 27% are amendments, which are filed when the employee moves work sites, has an increase in their pay, or there is an otherwise notable change in their working conditions. The report notes that some of these amendments are filed with an extension of stay, and 20% are for changing employers. The breakdown of country of origin for approved H1B beneficiaries is as follows. 72.3% are from India with 279,386 beneficiaries, 11.7% are from China with 45,344 beneficiaries, and all other countries of origin represent less than 5,000 beneficiaries, with the Philippines being the only country to represent greater than 1% of beneficiaries at 1.2%. The gender breakdown of H1B beneficiaries is predominantly male, with females representing 26% of continuing employment approvals and 30% of initial employment approvals. This could indicate that the proportion of females who are approved for continuing employment may grow in the future. Now, on to education. So the breakdown of education level is as follows. With bachelor's degree, with 35% of total approvals, and 33% of the continuing approvals, and 37% of the total initial approvals. Master's degree, which is 20.5% of the total approvals, 24% of the continuing approvals, and 17% of the initial approvals. Doctorate's degrees represent 9.5% of total approvals, 5% of continuing approvals, and 14% of initial approvals. Unknown education levels, which means that the education level was either not required in proving the equivalent experience, or that the level of education was not recorded electronically by USCIS systems. Can you imagine that? The government had a computer system that broke down? Where was I? The report attests that the latter is the reason for the higher number of education unknown petitions. They represent 31% of total approvals, 35% of continuing approvals, and 27% of the initial approvals. The employment categories that H1B approvals fall into is concentrated mostly in computer-related fields, representing 65% of approvals. The next largest categories are as follows. Architecture, engineering, and surveying at 9.5%, education at 6%. It is worth noting here, though, that the education petitions were 59% initial approvals, which is outsized compared to most of the other fields. Administrative specializations was 5%, and medicine and health was 4.3%. This also had an outsized amount of initial approvals. Next is salary ranges. Before delving into this section, I believe it is worth keeping in mind that the requirements for H1B work, specifically level of education and related experience, and that the average age of H1B workers is 33. So these aren't entry-level jobs, really. So the figures I list in this section are the median, but the salaries of the 25th and 75th percentiles will be on screen, as well as the mean. All right, so the salary ranges are as follows. For computer-related occupations, the median is $122,000. For occupation in architecture, engineering, and surveying, $113,000. Education, $69,000. Administrative specializations, $120,000. And occupations in medicine and health at $109,000. The last part of the report I want to discuss is the prior status of H1B beneficiaries. There is some more information in this report, but it's a little more granular than I want to get in this video. It's more like demographics of sub-demographics. You're more than welcome to check it out. The report will be linked in the description below, but I'm going to skip over them for now. So of the 118,948 initial employment approved petitions, which were roughly 50% of those were from outside of the country, or that otherwise requested to enter the U.S. via a port of entry or a consulate. The remaining 50% were those already in the U.S. And the breakdown of that remaining 55,916 petitions, I believe, is worth noting. Of these requests to change non-immigrant status to H1B, 72% were students on F1 or F2 visas, 11% were exchange visas, and 8% were the spouse or child of an H1B visa holder. And that's it. That's the extent of what I'll be covering today. Of course, if you wish to look more into this yourself or wish to issue a correction for something I said, the sources I use will be linked below. Fair warning, it's US code, it's dense, so buyer beware, I guess. Again, I don't intend for this video to be an opinionated piece, but hopefully something people can use to learn more about the program. So with that, good night all. Have a wonderful rest of your day, and let me know if there's something else you want me to cover. Thank you.